Just to address Senator Lombardi's question about failing to ensure that all reasonable steps are taken to enable a viable fetus being carried by their patient to be brought to term, I'm looking at it in a vacuum. If this is it seems to address the context where a woman has come to have a termination, and that's totally inconsistent with that, or taking all reasonable steps to ensure that it be brought to term. Well, that could also interfere with the life or health of the pregnant patient, and that would make it unconstitutional under current law. So I think it is, the sentiment, frankly, is certainly consistent with the doctor's oaths right now, but the way the language is written actually puts a different balance, and as it reads, suggests that trumps all other considerations under our current jurisprudence.
Senator Lombardi.
I was just suggesting the reasonable nature, the reasonableness language. Certainly in light of Roe v. Wade, which is currently the law of the land, this statute could not pass as it exists right now. Right, but I was concerned, I thought I heard the doctor say that if given the choice, that very difficult choice between the life of the mother and the fetus, I thought that somehow that could be deemed to be unreasonable, and I just don't see that it's unreasonable. That's all.
So I now want to turn to my the focus of my presentation. My name is Lynette Lavender, and I'm a volunteer attorney with the ACLU of Rhode Island. Last year, I addressed both the House and the Senate in support of legislation which is designed to codify the principles of Roe v. Wade and preserve the current rights and protections to reproductive freedom of choice enjoyed by women in the state of Rhode Island. The current bill, Senate Bill 2163, addresses all of last year's criticisms and is designed to do nothing more than codify the current protections extended to all women by Roe v. Wade and its later cases, and to reflect the current state of the law of Rhode Island by cleaning up our Rhode Island law books, which continue to reflect old statutory prohibitions that have been declared unconstitutional or permanently enjoined, but for some reason have never been formally removed from the statute books. I'm proud to say that I was actively involved on behalf of the plaintiffs and with the ACLU in obtaining many of those past determinations. When threats to a woman's exercise of her decision whether or not to bear children or to terminate a pregnancy were imposed right here in Rhode Island. While it has been more than 15 years since the ACLU has been forced to challenge any such law in Rhode Island, the threat of interference with the highly personal and private exercise of those rights could not be more stark. Many advocates of reproductive freedom are deeply and understandably worried about the future of Roe v. Wade in a reconstituted United States Supreme Court. Even if Roe itself is never overturned, there is legitimate concern about the court eroding the principles underlying that decision to the point that a person's ability to make this highly personal and private decision is denied, with the government making the decision instead. The General Assembly can ensure the preservation of the current state of the law in Rhode Island by affirmatively removing these old, obsolete placeholders and recognizing the paramount right of women in our state to decide for themselves whether or not to bear children. Once the dust settles at the national level, if there is new room to legislate, then the current or a future General Assembly can thoughtfully address the need for legislation based on current norms and standards. It should not be dictated by legislatures of the past whose enactments were previously struck down. The proposed legislation is designed to preserve those provisions affecting abortions that are presently in force and conform to Roe v. Wade. It preserves basic informed consent and the requirement of parental or judicial consent for termination of a minor's pregnancy. It preserves the rights of individuals who object on moral or religious grounds not to participate in termination proceedings, and it preserves that portion of Rhode Island General Laws, Section 36-12-2.1, which prohibits the state from including abortion coverage as part of basic health insurance to state employees. At the same time, the legislation makes clear that the many provisions previously struck down or never enforced as fatally flawed are now formally repealed. And on that last issue about never enforced as fatally flawed, I'd just like to address my colleague here, Mr. Bracy. The quick child statute has been on the books since 1975, and it's never been enforced. It was subjected to a constitutional challenge that didn't go anywhere because there was a finding that no one had standing because it wasn't being enforced. The law is fatally flawed because it does not have a provision of an exception for the life or health of the pregnant woman, and that's why, even though it sits on the books, it's never been enforced. My colleague Faye Dion and I prepared a 6-page memo and a 1-page fact sheet which directly refute the unfounded claims of critics of this bill. I would also respectfully take issue with the explanation by the Legislative Council, which does not accurately or at all reflect that this bill does no more than preserve the status quo. I look forward to the committee's favorable consideration of Senate Bill 2163, and I would be pleased to answer any questions you may have. Thank you.